I'm going to share my screen, get set up. I got somebody in the waiting room.
Good looking crew there.
George Bachman in. All right, so try this again. All right, there we go. All right, John, if you want to start us up, we can.
Okay,
go
great,
from there.
great, Tom. Thank you very much. So welcome everybody. Tonight we're going to have a presentation called A Different Hand to Play. And this is part of a series of presentations that we're going to be making perhaps throughout the balance of the year on different topics, but this is a special topic for us as an organization. A number of years ago, an associate joined us. His name was Al Dolan, who said, "Hey, I want to work in the special needs community and working and serving that community." And I said, "Well, it's interesting you arrived. We kind of a catalyst for us to. I'd worked with an organization in the past that had done this. We said, hey, we would like to try to foster some support for that community through our organization. So we have developed over time a thing called the Special Needs Resource Network. And the company that we work with, One America, caught fire of some of the things that we were doing, or caught wind of it, and they helped us develop some material, including this presentation that Tom is going to give tonight. And Tom joined us a year or two later and saw that what we were doing in this, he had an interest in nonprofits and said, hey, this is really pretty interesting stuff and has really helped us sort of take it to a new level. And what our objective here tonight is to give information about some of the issues that people run into when they're, dealing with special needs family members and how to provide support and where to get resources for them. And Tom has done this presentation a number of times and has really developed some expertise in this particular area. And I think that you will enjoy this information and find it to be knowledgeable and hopefully can be of benefit to you. And so with that, I'd like to introduce Tom Alessi, who now has about 20 years in the business. And as I often say, he's also the former chief marketing officer of National Amusements, which was a great movie company. So Tom, take it away.
Certainly appreciate it, John. Thank you for the intro. I'm going to fly through a little bit this as we start because we try to keep on time here with this. This is just a quote from Mother Teresa in terms of going through it. I do have to touch on the disclosures as we start up here. Just so you know that this information that it's purely educational and informational purposes. We're not giving you anything that isn't what is currently constituted out there in the world, right? We didn't make up any of these numbers or anything. One of the things we do say is you get to the bottom there with the disclosures that if you ever do have either legal or tax questions or concerns, that you seek out the help of a professional. And that's part of what John was mentioning, what we've done with the Special Needs Resource Network. I'll touch on that in a second, just a little bit more about the Special Needs Resource Network. But we do suggest that you find that professional to ask those questions of. Quick little checklist with tonight for the presentation. The event's being recorded. You don't have to worry about your name or your image being shown because only what's on the screen is what is being recorded. Just keep your microphones muted. There is a chat box, so we ask that if you do have any questions to type them in the chat box. What we're going to do is hold off until the end so we can try to get through this because there's a lot of information and we want you to be, on top and taking notes and really following along. If you do have a question, throw it into the chat box. We will try to answer those questions at the end of the presentation. And just want to jump into it from there. Like I said, John did most of the introduction, so I'll sort of skip through that. Talk about expenses, government benefits, how they impact, why they're important, special needs trusts and the 529A ABLE accounts, how they offset each other, some of the different ways to future fund or fund a special needs trust, some advanced directives, caring for the caregiver, which is very important, and then some other resources we go through from there. So as John mentioned, the Special Needs Resource Network, really, the whole mission for the Special Needs Resource Network, as John had said, is trying to help that family with a child who's differently abled or has a disability. And our goal is to try to connect to as many organizations, advocates, and other professionals so that we can be that support and resource. And that's really the idea. So if you do have questions, whether they're on a tax or legal, you can reach out to us and we can try to connect you to somebody. That's the whole idea behind the Special Needs Resource Network. Okay, so, raising kids is tough. It's challenging no matter if they're typical or if they have a disability or a special need. It says there that there's 21 million Americans. I think that number is higher now. This is probably a slide that's probably from a year or so before COVID type of thing. So that number is probably closer into the mid 20 million range. But for us, we see that as a positive, because what that means is what you're seeing is more recognition, which means early diagnoses, which means better treatment. For everything that we're seeing out there, we're seeing this as the trend that is going from what used to be awareness to now acceptance, right? And so, that's a big part of this, and it's trying to get the understanding out there, and certainly with more diversity and inclusion going on, that's a big part of this. But no matter what, you're always going to run into, that having these mixed emotions and different experiences. Everybody is generally, following the same journey. You're just not on the same path on that journey as you're going along. And, so it says almost 20% of Americans are disabled. And that number, like I said, that's probably somewhere in the mid to high 20s, maybe 30 million people when we're talking about the population, which again is going from awareness to acceptance now. But the other part of that is that few of these, because of the diagnoses, because of the medical treatments, that fewer of these become life-threatening, and that the likelihood is that more and more children are outliving their parents in the great grand scheme of everything. So, which is a blessing. That's what you want. As a parent, you never want to, outlive your child. So this is benefits, treatment that's happening. But the reality is that means longer lifespans and more costs, ultimately, when we're dealing with going from a child into adulthood and then living, past your life expectancy, which brings those numbers. You can see them there. It says, the average lifetime cost, it's 1.4 million with a child with autism, 2.4 if there's more complex, and different disabilities, versus the average child, which is about 250,000. I don't know that that's including school, because that seems like what I'm paying for, college at this point. Just understand there's cost to that, and we're going to get into the reasoning behind why that's important and understanding it. But no matter the circumstances, the resources are there so that you can put the plan in place for this. And really the analogy that we use when we talk about planning is it's similar to you as an individual planning for your retirement. Right? So you're planning your retirement. You've got to know what you're going to need for expenses so that that's going to last for you for the rest of your life. Very similar if you're dealing with your child as they morph into adulthood and what we're doing for those expenses, right? And those expenses, some of these, when we talk about typical costs here, are for them now. But some of these are the same expenses that they're going to have as they get into adulthood. Transportation, probably personal care of some kind, therapy, medical copays, assisted technology. It won't be tutoring or private school, but it could be housing or some sort of living arrangement. The lost earnings, that's on you for now. That's care for caring for a child with special needs. But a lot of these are the same costs that you're funding now, your child is going to have as an adult. And so you need to be thinking of that and saying, well, then I've got to be planning out, 25, 30 years out for them in adulthood, or certainly a time period when I'm no longer around and able to help support them. And that's a big factor with it. And the reason we use the retirement analogy on this is because just like you, when you get to retirement, you've got a government benefit that you're going to access. That's Social Security. And your Social Security is meant to be there as a portion of your retirement. It is not going to fund your whole retirement. It's going to fund a portion of it. And you are going to fill in the rest of that. That's what you're saving into your retirement accounts and building up assets for. Well, similar conversation for your child when they get into adulthood. They are going to have government benefits available to them, Medicaid, supplemental security income, SSI, and Social Security disability income, SSDI. These are all benefits that are available to them. But just like with Social Security for you in retirement, where if you take Social Security early or you earn too much, you end up with penalties or paying an assessment or taxes on it. The same thing happens to an individual who's disabled or is differently abled or has a disability, that they are only allowed to earn a certain amount, have a certain amount of income, or have a limited amount of assets. That's what the means tested portion of this talks about. For Medicaid, for example, that's $2,000. If they have more than $2,000, they'll be disqualified and not covered for the benefit. So you have to think of ways that you are going to be able to portion those funds so that they don't get disqualified, because just like Social Security is a limited benefit that's helping you in retirement, these programs are helping your son or daughter as they're in adulthood and trying to maintain their lifestyle and their living. These are a safety net. That's pretty much it, just like the same concept with Social Security. It's a basic for them. And it's something that you want to make sure that is being protected. And that's really what we're going to get into here, is how can these benefits be protected? How can you plan out for your son or daughter out into the future? And so one of the first ways that we talk to everybody about that is with a supplemental needs trust, otherwise referred to as a special needs trust. Now, special needs trust comes in a multitude of flavors. Mostly you're going to see them either as a first party or third party trust. A first party trust, and we'll go into a little bit more detail with that next, is just that the first party is the individual. So your son or daughter is the person setting up the trust and the person funding the trust. We'll talk about that in a second, like I said, about how that works and why that happens. The rest is third party, which is just somebody other than the beneficiary, i.e. your son or daughter, is setting up and funding the trust. That's the third party. They are the most common because really when we come to the flexibility and the availability and protecting the money, they're the most common. They're the most flexible. The money's available for your son or daughter. There's no disqualification from any government benefits. There's no limit on how much can be put into a special needs trust, third-party trust, right? You create the trust benefits the child. Family members, others can add money to it, siblings, relatives, friends, it doesn't matter. The money can be poured in from anywhere. And then you can fund it with estate assets and life insurance. That last part we're going to talk about in a little bit, because that's more on the lines of I'm future funding this trust. And some of that gets into a little bit about how we're future funding, the ways we're doing it, and some of the assets that we might be looking at or using, and how that can trip us up a little bit in going forward with this. But just know, the third-party trust, the reason it's the most common and what most of the time you're going to see information or hear anything when dealing with a supplemental needs trust, it's because this is the most common way and the most flexible way to set that up. So what are the advantages to it? Like I said, the flexibility, but the trustee basically controls distributions, and there's no caveat, there's no limit to it. There's nothing that says, oh, it can't be used, or you can't give it to them for this, or you can't give them to them for that. it's basically if the child needs something, the trustee can then distribute funds to them, and it's for their use, it's for their purpose, so there's no disqualification. Now, the trustee should have a little bit of say in that, if it's somebody who does have the ability to drive a car, say, do they need a Tesla versus a Civic? I mean, there were some limits here that couldn't go into it. But for the most part, this is governed by the trustee, and the trustee has the ability to then say, yep, no, we're going to fund it. We're going to get the kid a car, and they're going to be able to use that. The other thing that comes up with this is that if there are benefits, if there's money left in the trust and the beneficiary, the son or daughter, passes, then there can be named other beneficiaries who can then receive those funds. There's somebody other than the beneficiary. If the beneficiary passes, the money can get passed on to other beneficiaries, including charitable organizations, if you're so inclined, at the passing of that beneficiary. The difference, and we're going to talk about it in a second with first party and other trusts, is that Medicaid specifically will put on a reimbursement, a clawback provision that says, if the child passes, the beneficiary passes, and there's money in the trust, well, then Medicaid's going to step in and say, I want the money back. We paid out this amount. We got a clawback. We want to get paid back on that before any other distributions can occur. So what are the drawbacks? Honestly, it's costs. Like in this area, you're probably looking at, we're in Boston, so Massachusetts, probably somewhere between $5,000 and $10,000 to set up a supplemental needs trust, a third-party supplemental needs trust. Depending on how that arrangement is set up, the trust funding that goes into it, that there can be minimums on that. And some of those can be, you just got to put at least 25,000 in to start. And then they're managed by, trust companies. So there can be fees that go along with it. That's the downside to a third party trust. It's really the high cost to get in and then determining how the asset is being held and where it's being held and if there's a cost associated with that. The other types of trusts, so you have, I mentioned already, first party trust. So you may say, well, that's the beneficiary. Why is the beneficiary setting up a trust? Because what can happen is there can be a situation where an inheritance is given. That's, we talk about good intentions, unforeseen consequences. It could be a situation that the beneficiary is the recipient of a medical malpractice lawsuit or was in an accident and received a compensation from that. Well, in that situation, they've got money that they want to protect, that they still want to get their benefits. So they set up this first party trust. Now, first party trust is more limiting. They can only be used for basic needs, unlike a third party trust, which can cover a lot of different needs. And as I said, there is this clawback provision that should the individual pass, Medicaid will step in and ask for their money back. The pooled trust arrangement and the state ARC, they're similar. We don't see too many state ARC trusts in this area, see more of the pooled trust arrangement. Pooled trust got a funky name, but really the idea is it can be either set up as a first party or a third party trust. And it's run by a nonprofit organization that generally what they're doing is they're setting up and creating the trust. It's based off of, the trust is drafted in such a way. The assets that are put in are managed in a pooled arrangement. Your fund for your son or daughter is separated. It's completely separate, it's always separate, but it's just how they are managing the asset itself is the pooled arrangement. Regardless of whether or not a pooled trust is first party or third party, there is a clawback provision that occurs, just like the first party trust, a standalone first party trust. In a pooled arrangement, there's always going to be the Medicaid clawback provision. The difference between a pooled trust, third party pooled trust, and a third party standalone trust is the cost. In this area, you're talking probably somewhere around $500 to $750 to set up a pooled trust versus the 5 to 10,000 of a standalone third-party trust. So depending on what you're trying to do, it might make sense to look at a pooled trust versus a standalone third-party trust, especially if we're talking future funding the trust, i.e. using assets that we're going to use once we pass or down the road, because setting it up with a couple of $1,000s today to, fund something in 30 years down the road, it's a little daunting and a little tough for families to try to get through. So can you do this without a trust? Yes, right? Not recommended, but you can. One of the things you can do is you can just leave the assets to your child. So going back to that whole, and the reason we keep coming back to the retirement analogy, this would be like you getting to retirement and then saying, you know what, I understand U.S. government, you want to give me Social Security, I'm not going to take it. Thank you, you keep it, I worked all this time and put into it, but I don't want to take it. So the same thing would be here is if you left the money to your child, they would have the asset, but they would be completely disqualified for any benefits. So the money that you leave them had better last them for the rest of their natural lives, because otherwise, if they run out of money, they've got no place to turn. There's no asset for them. This one's on there. It's called, you can disinherit your child. I'm not really too thrilled with this one. They keep it in there. Yes, you can do it, but it really doesn't do anything for the child. It's just whether or not that they have assets or that they were assets that were not given, they're still just left with the government benefits that are available to them. That's all that does. So disinheriting them, I don't like that it's in there, but it's part of the presentation. You can leave the assets to a trusted family member. This one, there might be an older or younger sibling who's very involved with your special needs child and willing to step in and be that person for them once you pass or once you're no longer able to handle it. And that's great. All good intentions. Love to see that where families are, certainly have that bonding and there's that strength going through. The problem there is this is money that is then left in another child's name. What happens if that child gets involved in a lawsuit or is in a marriage and suddenly gets divorced? Those assets are not protected from those proceedings, which means even though little Timmy was going to take care of Susie or Johnny, who's got a disability, the money's gone because it was taken in the lawsuit or taken in a divorce proceeding. So good intentions, unforeseen consequences, not always recommended that that's something to do. And the last one there says, well, yeah, you can just, not have a plan. Well, you have a plan. Your plan is I didn't plan. I just, I waited till the end of the line and then that's what happened. And we'll see what's left at the end there. So again, not a strategy or recommendation really when you come into it, but you're talking about funding, a special needs trust, funding that supplemental needs trust, and not all assets are created equal. Specifically, I just had this conversation with somebody the other day, talked about, well, I'm going to leave the retirement account. I said, that's great, but when you're in retirement, what are you going to live on? Well, the retirement account. Well, how long are you going to live? I don't know. Well, what if you live 20 or 30 years in retirement? What's going to happen to the assets? Well, they'll probably spend them. So then what's going to be left? I don't know. So retirement accounts, while it's a good idea, it just necessarily, this is usually your retirement that we're talking about, and depending on how long you're living. Certainly, as a beneficiary, you can. I will give you a word of caution here. Here's one thing with that. You want to make sure that if you're leaving a retirement account, whether it's 401k, IRA, whatever, that you set that trust up as an accumulation trust and not a conduit trust. So accumulation, not conduit. Accumulation means that the trustee has the ability to take those required minimum distributions and allocate them back to the trust. They do not have to pass them, that's the conduit version, on to the beneficiary, because an RMD could possibly create a problem depending on the size of the amount that's in the retirement account, create that you've over the limit. You've now created a taxable event, you've now created income, and you created an asset, you're disqualified for benefits. Quick note here with the Secure Act. So one of the things the Secure Act kept in place was the ability for somebody who is diagnosed, has a diagnosis, is disabled, has the ability to stretch IRAs for their lifetime. The rest of the world is held to a 10-year withdrawal, not the case for somebody with a disability. They are in a stretch, which just means if it's your son or daughter and you pass at an early age, they can stretch it for their lifetime. So the RMD with the distribution that's coming out isn't going to be that severe than if you had to take it out over the 10-year window. Just another point to that. All right, so you want to leave real estate. Great. You know, I want to leave the house. They're going to be able to live in the house. Tremendous. That's a great thing if you can do that. But is there another asset that's going to be set up that's going to allow them to then take care of it? Home maintenance, you've got taxes, you know, you've got other things that go on. If there's mortgage payments or other interest that needs to be paid, you know, a lot of that is a consideration. And great that you left in the house. We say, well, okay, they can sell the house. Well, then it comes down to, can they? And how quickly can they do it? Now, right now, we're in a, you know, you put something on the market today, it's gone in 3 days, but you don't know when that's going to happen to them. And it might be a sluggish market, and it might be a situation that that piece of property doesn't sell right away. What are they doing for money then? They're not going to qualify for any type of equity or reverse or any way to get the money out of the property. So while real estate, good intention, maybe not the best thing to be leaving to them. And then you're dealing with securities. Again, another thing where it's a good intent. If you're not using it for your income in retirement, sure, I can leave it to them, right? But then who's going to manage it? Whoever's managing it, how is that being taken out? Is there somebody who's acting as a trustee, or in that case would be, we'll get into guardianship a little later on, a conservator who's then overseeing that as the money's coming out? And who knows what the market's doing in terms of fluctuation? So again, future funding this with some of these assets, while great intent, may not make the most sense when we're really trying to make sure that there is a pool of money available or an asset that's available that you know is going to be there to fund your son or daughters the rest of their lifetime so that they can continue the lifestyle and lead the life they want to lead. And the only way that we know to do that, where you can do it as efficiently as possible, is using life insurance. Because life insurance is that one asset that you can absolutely say, I know this is going to be here. When I pass, that's going to be available. And so life insurance is there. It's the most efficient way that we know of to fund a supplemental needs trust, because it can fill the gap between what the benefits that they're going to get and what they need for their lifestyle. You can figure it out, you know, go through that all and decide what that amount is and figure out what you can afford, what the family can afford to have for coverage to fund out into the future. And there's no other way that you can absolutely say, I know it's going to be there when we get to that point. And you really want to find the amount that's right for you. Right, that comes down to it. Maybe, hey, we'd love to leave, you know, Junior $500,000, but it's not economically feasible for us to do that. It might only be 100,000 or 150,000. But you know what? It's an amount of money that you know is going to be there, which then turning it around and going to your retirement picture means that you can then spend the assets that you have in your retirement account or in your other savings for your lifestyle, because you know that your son or daughter has been taken care of. So, you know, like I said, you know, premiums, I'm sure you figure it out. This is what it's going to be. Premiums get paid. It gets funded. I will say one of the things with that is that, you know, once you pass, that money is payable immediately. You set the trust up as the beneficiary, and it goes right from the beginning. You know, once it's paid, it's immediately payable. So it's never a thought like, oh, gee, you know, I got to wait some time for this. No, it'll be fully funded. Like, so if something happened to you next year, that trust would get fully funded immediately if you pass. You just name the supplemental needs trust as the benefit to the life insurance policy, and it's all taken care of. They never see it. It never affects them. The government never gets involved, and it never disqualifies them for any of their benefits. You know, so it's that the premium. So one of the things there is with the caveat here is that it needs to be a permanent policy. It can't be term insurance. And specifically, the recommendation there on the screen says whole life, because whole life is guaranteed. The premium's never going to change. There's never going to be an issue of it ever running out, because that's one of the biggest things with this. This is, you're talking about funding for for something that's going to happen for your child later on in life when you're not there. So you absolutely need to have that number and that guarantee available. Term insurance isn't going to work. Some other permanent policies aren't going to work. You got to be able to figure that out and build it in such a way that you have that amount that's available. Now, one of the other things that comes up are ABLE accounts. Excuse me while I take a drink. Right, so 529A, otherwise known as ABLE accounts, right? Achieving better life experience. That's what ABLE is talking about. So ABLE was put into law in 2014, right? But the first accounts really didn't come on the scene until 2016. We're talking just 5 years ago. But at that time, you had to live in the state that was offering the ABLE account. And back then, there was probably 6 or 7 states that had adopted 529A accounts. So it was very, very limited. So when they amended it, the Tax and Job Act in 2017 and the Able to Work Act and Financial Planning Act, just basically said, we're gonna take that off. We're going to make changes to this and we're going to make it more flexible. So it's going to act more like a 529 college savings plan. And that means that you don't have to live in the state where the ABLE account is set up in order to participate. Much better. And it made it a lot more flexible. Now I believe there's 30 states that actually have 529 ABLE accounts, accounts set up. But again, you don't have to worry about that. Here in Massachusetts, it's through MEFA, it's through the Mass Education Financing Authority. It's managed by Fidelity, but you can go to MEFA and just look that up. That's who the 529A, it's called Attainable Plan, is through here in the state. But you have flexibility. You can go to any state. They're right now not giving you any tax advantages in Massachusetts for funding into an ABLE account. But so what is some of the advantage to it? It's easy to establish, right? Any of the money that's sitting in an ABLE account does not count against, for asset, for means testing purposes, any of those government programs. The funds grow tax-free. However, right now, the law in place is that the the diagnosis had to occur prior to age 26. Now, right now, legislation is in place, and I believe by the end of this year, that will change, will be 46, right? It's on the table right now. They're voting on it as we speak. It's running its way through Congress at this time, but they are going to push that number from 26 to 46. Because if you think about this, there's some, especially when we're talking about low vision, vision impairment, blindness, a lot of that happens later on in life than early on. So they realized there were limitations there. That funding limit may sound like a big number, $100,000, but you'd be surprised. It's $100,000 is maximum that can be in the ABLE account. You go over $100,000, immediately you're going to be means tested, and SSDI, Medicaid, they're going to stop at that point because you've gone over the limit. So what it just means is that once you get to that, you want to make sure that the money is being spent down so you don't trip over the $100,000 marker. And just like a first party or a pooled trust, that if the beneficiary passes away and there's money in the account, Medicaid is going to come back and say, we're looking for reimbursement. We've got a clawback here. We want to have that payback provision in terms of it. So that's the disadvantage there. But who can contribute? Pretty much anybody can contribute. This is a great way to set up for those if family members want to make, gifts on birthdays or, some other events like that, there's a way that they can put it in. Now, there is a limit to it. You can only fund in $15,000 a year from every resource. So parents, grandparents, friends, relatives, everybody, the maximum that can be set up is $15,000. You can only have one ABLE account per beneficiary across all the channels. So it's just one account, and the maximum that can get funded in is $15,000. Now, however, the individual as an adult, if they are out and working, can contribute their own funds up to, and again, that's the 2019 number. I don't think they changed it at this point. The maximum is $12,490. So if they're earning money, they can take that and put it into the ABLE account as well. And again, it won't count against any of the government benefits. We're going to talk about all the expenses, the qualifying expenses in a second, right? And again, you don't have to live in the same state. And you can also transfer, if you have funds that are sitting in a 529, a traditional college savings plan, they are able to transfer into the ABLE, the 529A, with no penalty. There's no problem. There's nothing to that. It's an automatic thing, except for you've got to stay within the limitation. You can only transfer $15,000 in a single year. It counts to that whole maximum amount that can be added in for the beneficiary. So real quick on those qualifying disability expenses, it's pretty much just about anything when you really look at it. I mean, it gets very, very extensive in terms of, transportation to, from, anywhere, employment, medical visits, anything like that, training and support, job coaching, along with the basic housing and other living expenses and items. One of the interesting things with this is, so let's say your son or daughter is living in a home where they're paying, it's a assisted living or there's some sort of an expense to them, and they've got a housing allowance for that. But the housing allowance doesn't cover all of the expense. So you think, well, I'm going to take the money out of my special needs trust that I've set up to pay for that difference between what the housing allowance doesn't cover. If you do that, you will disqualify the housing allowance. It's a weird thing. The special needs trust does not allow you to pay for that housing allowance benefit. However, you can use an ABLE account to pay for that housing allowance. So if you follow me, the idea would be I can take money from a special needs trust and put it into an ABLE account, and then have the ABLE account be like almost the spending account for my son or daughter, where they can certainly use it to pay for housing or other basic needs. Again, we're not disqualifying from any program. So it's more of, it's not an and or for us usually between special needs trust or ABLE account. It's more of how these work hand in hand, and that you can certainly be looking at having both to create the flexibility for your son or daughter as an adult, and ways that they can have funding and have funds. And if they're out earning, they can put money away where they're not disqualifying themselves. But you've got this ability to sort of set up and fund for different expenses depending on what they are and what their needs are. All right, let's get into some of the legal stuff here with this. A will is the same. If you don't have a will, again, the recommendation is speak to somebody in a legal profession to get it done. If you need help with that, we have attorneys that we work with that are part of the resource network that we can help you, but the idea there is that the will dictate not only where assets go, but it will dictate guardianship for an under 18 child. And that becomes, we're going to get to guardianship in a second, something to be really thinking about. So recommendation is if you don't have a will, make sure you get one. But, because we're talking about division of assets, well, if I only have one child, that's simple. I'm going to pass everything to, if I'm married, everything to my spouse, and then everything will pass to the child. Easy. But what happens if we've got, more kids? Some typical and some special needs. Well, now I got to figure out how I'm dividing those assets, where that makes sense, and why that might make sense. And then, this gets into the conversation where it might be, well, gee, I've got the house. I want to leave the house to my typical children. I'm going to set up that life insurance policy that will fund a special needs trust. And now I know that my special needs child has been taken care of and the typical children have been taken care of. But this is one of the things as you're going along and thinking about it, division of assets, estate, how that's all working. So guardianship, right? So this is the chair of the Autism Speaks, the Long Island chapter. Guardianship is the only way I can make sure that his mom or I will be able to advocate for what is necessary so he will be safe and happy. To secure this, I must prove to a court that my son is incapable of making decisions on his own. My wife and I must also choose someone to accept this responsibility when we are no longer alive and who we can trust to carry out our wishes. So guardianship, we're going to talk in a second. We'll go through, some of the concerns for child under 18. This is talking about now we're getting to the point where your child is reaching age of majority, 18 years old, and you have to make the decision, should you become guardian for your child? Because once they're an adult, they're making decisions on their own. You've got to make that determination as to whether or not it makes sense to get guardianship. The recommendation is that you should probably, especially now, we're still coming out of the whole COVID thing, that sometime around age 16 to 17 that you make that determination and start the process. Because the process used to take 6 months. I'm hearing, what we're getting for feedback is now it's longer. It's probably 7 to 9 months now because the court system's all backed up with everything. So the recommendation is if you are considering guardianship for an adult child, to do it before they turn an adult 18, so that you should start it probably sometime before they turn 17 at this point, okay? Conservatorship, which is the other portion of this, is just about handling the finances, not full guardianship. You're only going to be handling money matters and things of that nature, contracts and getting into agreements and handling that. Might be something that if you have somebody who's out working and dealing with stuff, that conservatorship is a route to go. We do a whole nother thing on guardianship and conservatorship because it's much more detailed. But just know from the timeline point of view that the recommendation is that sometime around 16 and a half years old, you should have that conversation and decide, because once the child becomes an adult, it is much harder to become the guardian, and it's a much more detailed and involved process. But so, a step-by-step process in terms of a younger child, well, the will is naming the guardian, right? And so this is a consideration that you really need to be thinking about, like from the quote there, somebody who's going to be able to step in, somebody that the child is able to interact with, somebody the child is to have a relationship with, who understands and can take this on and is willing to take on that responsibility. It's a big ask, and it's something that you need to go through, but you really got to take your time with this. Determine it in some cases if you can. Maybe it's the conversation with the child or other siblings that are involved, to get them into the conversation and to think about it. But there's a lot that goes into that. This is all the way up until 18. Once the child becomes 18, the will no longer prevalent. It doesn't matter. The child's an adult at that point, and we'll get into that in a second, because some of what happens with that happens if you die without a will, right? So then we get into intestacy laws. And, one of the things that happens is everything goes to probate. And probate is a cost. Probate is going to take away assets that you were planning on leaving to someone else because it has to be dealt with through probate. And one of the other biggest factors there is that those assets are divided up based on relationships. They're not really caring whether or not, your differently abled or disabled son or daughter maybe ignore the money, which was your intention to leave them. They're just going to look at it and say, no, we're going to distribute it out this way. And the last piece there, what happened there? It didn't work. and then the court selects the guardian. So understand, this is family court, and family court is just going to be making the decision. They're going to be just review things very, very quickly and decide who's going to be the guardian for your child. That should absolutely be the number one reason that if you don't have a will, you get a will for a child who's under 18, because you want to make sure you're dictating where your child is going to get cared for. And we'll talk about that later at the end when we get into, the intentions with everything. So encourage other family members, if you have, that they should have wills as far as going through that. That's about leaving and distributing assets. We'll talk about that when we get into beneficiaries in a second. Just know that the laws differ from state to state. So Massachusetts is different from New York, is different from Iowa, etc. So if you have family in other states, you want to just check on that, or if you plan to then relocate to another state, you just want to make sure you're up and understanding what those rules and regulations are from that. But, again, having the special needs trust, it becomes that flow through that you can name for some of those assets through the will. One of the factors with that is not everything passes by a will, right? The life insurance, IRAs, benefits, annuities, savings bonds, all of this stuff passes by beneficiary. And so one of the things we recommend to everyone is that you're constantly doing an upgrade, a review, an update of your beneficiaries, because you want to make sure, what happens is a lot of times husband names wife in reverse, and they don't name we'll talk about contingent beneficiaries in a second. And what happens there is there's a little checkbox sometimes that says in stirpes, which just means, hey, if you predeceased him, we're going to pass all of the assets to all of the children. And if your special needs child ends up getting assets, it's going to disqualify them from benefits. Good intentions, unforeseen consequences. So you want to make sure that if you've got IRA, life insurance, annuity, whatever you might have, that you've named not only a beneficiary, but you've named a contingent. That is a backup beneficiary. Should the primary beneficiary predecease you, it's got somebody else to flow to. Now, in the case we talked about with IRAs and life insurance and other things, if you have a special needs trust, you can name the special needs trust, but it might be a situation that you're passing to your spouse, and then the contingent beneficiary can be the supplemental needs trust. There's just a way to look at that and to go through it. But again, if you take nothing else away from this, it should be that you should update and review your beneficiaries at all times. So redirect gifts from family and friends, right? So again, this is the grandma or grandpa wanted to leave money to your child, and they didn't realize that if they left them in the inheritance or they gave them a gift, that it was going to disqualify them from benefits. So this is just those unintended consequences. You just want to make sure that you're having the conversation. If you have the special needs trust set up, that they can direct it there, or if you have an ABLE account, that they can direct it there. Ways that the money can pass where you're not jeopardizing or putting any of those benefits in trouble. Communication goes a very, very long way in all of this. So finding the right team, this is just, like I said, for us, we always recommend if you've got questions, whether they be legal or tax, you seek out the help of the professional for that. You've got financial questions, come to us. That's what we're here for. If you don't have an accountant or an attorney that you can turn to, or doesn't have qualifications or doesn't deal with special needs, come to us. That's what the Resource Network is all about. We're here to help and try to direct and get those questions answered as quickly and as efficiently as possible. The last thing I want to mention with that is the letter of intent. The letter of intent, this is probably one of the most important pieces. And the letter of intent is not a legal document. However, the letter of intent will carry a lot of weight when presented to court when looking at guardianship or dealing with the child. Because what you're doing is you're documenting what your child likes. They're, everything about them, the medical conditions, doctors, teachers, school, where they go, how they go to bed at night, ways that you keep them calm. All of those things should be journaled in a letter of intent. It's something that you want to track as the child grows and matures, add to it. Because this is something that the court will take into consideration when we're talking about guardianship or intent for things. You just want to make sure that there's something there that says, this is my child, this is who they are, this is what I want for them and what we're trying to do for them. And that will go a long way to, smoothing out any of that transition. Legal and financial, any of the trusts or anything that you've set up for them, part of that as well. Document it all together and keep adding to it. It's not like, hey, I did this once. We recommend usually sometime around age 10 or so that you start this and then build on it. Maybe once a year, maybe on their birthday. You just go back into it, look at it and see if there's anything new that you wanted to change or update. But it's important to keep the letter of intent as you go along. All right, so care for the caregivers, this is just more about realizing that, you need to find time for yourself, even if that's just taking a regular break at some time, because you're, trying to take it all on yourself is going to be detrimental out over time. So it's finding that support group. Again, if you need resources for that, come to us. We can try to help you, connect you with some support groups. Other families that are in a similar situation, but just trying to get yourself out, getting a break, doing something like that is going to go a long way for your physical and mental well-being. And build a strong support group. It's just a basis of figuring that out and trying to find places that you can go, not only for physical support, giving you a break, but mental and emotional support as well. Last word on that with the caring for the caregivers is just understand that, as we age, we have the likelihood that we are going to need care. And part of that is that some of that care is going to be a cost. This is why that conversation about using assets, using retirement funds or other securities or other things may not be the best, because you will probably need care. The statistic says right now that of the population over 65, that 70% of the population is going to need some kind of care. The likelihood that it's going to happen is unfortunate, and the funds that are needed to pay for that are going to come from someplace, and more than likely they're coming from those assets that you were planning to leave for the next generation. So you just want to think of the impact for that, how it's going to do it, and there are ways to sort of try to offset and bridge both of those conversations together. Final thoughts, you're not alone. There are support groups, there are support mechanisms, there are a lot of families that are in similar circumstances. When you're looking at planning out, start to think of this as you're building almost like a retirement plan for your child at the same time you're trying to build your retirement plan. What are their needs going to be? What are their costs and expenses going to be? And how are those medical benefits going to offset that? Look at the difference between special needs trust, the different type of trust, and offsetting, maybe using an ABLE account if you're in the situation of, I've got some funds right now, I want to at least set something up to get started. And, again, I can't stress it enough. The most efficient way to future fund a trust is using life insurance, because there's no way that you can leverage and guarantee that the benefit is going to be there, regardless of what else happens in your world and in your life. My co-partner in all of this, Craig, isn't here. This is us when we're out and about in our more formal attire. If you've ever been to any events, you've probably seen us at conferences and other things. Those are custom jerseys. They are number 12. They are Brady. We are thinking about changing it to Newton, because that would be number 1, and it's kind of a cool thing being number 1. But right now we're in the Brady jerseys because he's Brady and he's still playing at this point. One of the things that we are going to do is we are going to send you out an evaluation form. We value the feedback we get from everybody. This is a link. It takes you about 2 minutes. When we send it out to you, we just ask that you take the time, fill it out, send it back to us. Because like I said, we value and appreciate any feedback we get from any participants. We want to know that we've been on point, that the information that we conveyed that we got to you made sense and was something that you were able to take away. The other thing is we offer, as part of that, a complimentary consultation. You've got questions and concerns. You've got someplace, whether it's somebody in the resource network that you want to try to get to. You've got some concerns about planning or putting things away, or the difference between the trusts or an ABLE account. That's what we're here for. And we do that. There's no cost. There's no obligation to you. In fact, as for that, on the evaluation form, there is a checkbox that does say yes, that somebody would reach out. But right now, if you put in the chat box, you just say yes in the chat box, we'll have somebody reach out to you just to go through and set that up and see if we can be help or answer your questions. So I told you we were going to hold questions until the end. So if you do have any questions, shoot them into the chat box. We'll try to get them from there. But otherwise, I am going to put up that final screen. I'm going to the chat box to see if I can do this. This is tough for me when I'm trying to do everything. So are there any legal, ethical issues regarding guardianship? Well, so when we're talking about guardianship means you are in control of the child, every aspect of their life. So there are ethical and legal standards that must be held. You've got to go through the court, got to get that. You've got to report to the court every year as far as that behavior is concerned. So yes, there are definitely ethical and legal things that cover a lot of that with guardianship. Again, doing it before they turn 18 is much easier than doing it after 18. And you can do partial guardianship, and like we said, maybe just financial, that would be conservatorship. So there are different ways to do that. John, you wanted to say something in closing? We're right up at about the hour, which is what we try to do this morning.
Okay. No, Tom, I just want to say thank you very much for your presentation. It was very informative, and I'm really glad that folks had a chance to jump on and learn some stuff. And again, what we'll be doing in the future is holding a series of these, so may even do this again. And we'd encourage you to, if you know anybody that could benefit from this information, please feel free to share with them who we are, and we'll get information out to them about when we're going to be doing this type of event again. And I just want to give Tom a thumbs up and a big applause. Matter of fact, I think we can do that. Give a reaction. I think that, and give a. What is it? The thumbs up signal if it comes through. I
certainly appreciate that. So I'm going to stop my share and say thank you for everybody. And I'm going to end the meeting and say have a great evening. Thank you.
Okay. Bye, Tom.